Good afternoon, everyone. My name is Lara Vivas. I am a partner at Cuatrecasas. We thank you very much for joining our webinar this afternoon. And we sincerely hope that everyone is feeling safe and well and staying at home as requested in most countries these days. This afternoon, I will have the pleasure of being joined by Alvaro Fernández, one of our senior associates, and also by our splendid knowledge and innovation department member, Ana Campos, to whom we sincerely thank for preparing also the scientific program for today. We will be covering a few of the news declared last week and approved last week by the government, and also some of the questions that we have been receiving in greater intensity during the past weeks. For that purpose, Ana will be also handling questions for the next few minutes, and also will give you information on how to contact us for further questions that you may have. So I don't know if Ana perhaps is not being able to connect. You can send the questions you may have.
Sorry, Lara,
Yep.
I had made a mistake. I had not unmuted my microphone. Thank you very much for that warm welcome, and I apologize for my mistake. Regarding the questions you may address us during this webinar, please direct them to webinars@cuatrecasas.com. We will try to answer them. If there is no time during the webinar, because it's a very short we have a very short time allotted to it, we will reply to you in the next few days with personal emails to each of you. So please don't hesitate to post any questions you might find interesting. Also, after the webinar is finished, there is another address at which you might direct your queries, and we will be very glad to assist you. It's queries.covid19@cuatrecasas.com. I repeat, queries.covid19@cuatrecasas.com. At either of these two addresses, you may direct your queries, and we will be very happy to assist you on any issue you may have regarding the COVID crisis. Cuatrecasas has a multitasking force assembled of all our areas, in which we will be able to help you either with labor and employment issues and any other area of the law that you will need to. So with much further ado, Lara, please, can you explain to us where we are, at what point we are right now at the management of this crisis, before Alvaro explains some of the issues some of the news of the last week. Thank you.
Thanks, Ana. Absolutely. So where we stand right now in Spain is rather easy. As you know, there was a declaration of a state of alarm in the mid of March. This has been extended several times, and right now the latest extension was approved last week, and it was approved until the 9th of May. So for the time being, this is the end of the state of alarm. However, we know that the state of alarm might be extended, and definitely that there will be sectors and industries that will not be completely released from the restrictions currently imposed, and that their restrictions will last for much longer in time. We are expecting also that there will be relevant news in certain industries, such as the tourism industry, that might be approved as soon as tomorrow. So there will be relevant items that will come up in the coming weeks. With that said, I will let Alvaro Fernández show us some of the questions that have been of greatest interest for our clients in the past week, and therefore that we thought might be of your interest for this webinar.
So yeah, hello to everybody. Thank you very much, Lara and Ana, for the introduction. And thank you very much to all attendees for joining us today in this webinar. It's a pleasure for me being here again with you. And I'm going to explain, well, the employment measures that have been approved by Royal Decree Law 15/2020. And what are these employment measures? So this Royal Decree 15/2020 includes a series of measures that modify or supplement the set of measures adopted until now concerning employment and social protection. The most noteworthy measures are the followings that you have listed in the PowerPoint presentation. So first one, and as you may recall from previous webinars, Royal Decree Law 8 2020 established, amongst other measures, the remote working as a preferred organizational measure of reducing or stopping the employee's activity, provided that this was technically and reasonably possible. And also the right of the employees to adjust their schedule and decrease their working hours up to 100% of their working hours if they provide evidence that they must care of relatives that require direct care and attention due to the exceptional circumstances caused by COVID-19. So as regards to these two measures, the new Royal Decree Law 15/2020 has extended its validity by 2 additional months following the month after the end of the state of emergency. In this connection, the state of emergency ended on May 9, and as it is currently scheduled, we will see if this is the final date or not, because, well, some news published today affirmed that the state of emergency could be extended for an additional 15-day period. We don't know yet, but, well, this is something that possible, so we will see. But assuming that the state of emergency will end next May 9th, these measures could be enforced until August 9th, 2020. That is a total period of 3 months during which, well, employees, if it is technically and reasonably possible, should remain teleworking or working from home. And also the employees will have these rights to reduce their working time schedules. And well, we consider that this extension is of major significance given the likelihood of the school year ending early, the lack of nursery resources and children's entertainment, and also the regulation on the staggered confinement of children, which will require adjusting employees' working hours so they can take care of the children's needs. So, yeah, the second measure adopted by Royal Decree 15/2020 is that temporary layoffs on the grounds of force majeure may be partial. So this new Royal Decree Law 15/2020 has clarified that companies can file for a temporary layoff on the grounds of force majeure if they carry out activities considered essential under the Royal Decree that declared the state of emergency and other regulations, if that temporary layoffs applies to a part of the activity of or the workforce that it is not considered essential. So this is a relevant measure. In addition, Royal Decree Law 15 has approved relevant measures on unemployment protection. First, as regards to termination during the probationary period, as you may know, if the termination of employment takes place during the first 3 months of the probationary period, the employees will only be entitled to the unemployment benefit if the previous employment relationship was terminated by a dismissal or by any other reason that allowed the employee to get unemployment protection. However, in most cases, the termination of the previous employment relationship was due to a voluntary resignation of the employee, and therefore, if they were terminated during the first 3 months of the new employment, they were not entitled to this unemployment benefit. So in order to protect these situations, the new Royal Decree Law 15/2020 establishes that all terminations during the probationary period at the company's request as of March 9, 2020, and while the state of emergency is in force, will give the right to the employee to get the unemployment benefit. In addition, unemployment protection will apply to those employees who voluntarily left their previous employer from March 1st, 2020 due to a firm commitment from another company to enter into an employment contract, and that company later could not meet that commitment as a result of the COVID-19 crisis. And finally, greater protection is also afforded to permanent seasonal workers, extending special unemployment benefits to workers unable to return to work on the scheduled days as a result of the COVID-19 crisis. Other measures included in the Royal Decree Law are those intended to reinforce the screening and sanction mechanisms to companies in order to avoid fraudulent attempts to collect undue unemployment benefits. Specifically, companies are considered to commit a very serious infringement if they present applications containing false or inaccurate information. The maximum fine in those cases could amount to, well, more than 187,000 euros, which is, well, a huge amount of money. So if companies contain false or inaccurate information when filing the temporary layoffs, for instance. In addition, Royal Decree Law 15/2020 provides for direct business liability, according to which the company must return all benefits an employee incorrectly receives when that employee has shown no sign of willful intent of gross negligence. Therefore, it is very important to file accurate information and fully comply with all formal requirements when carrying out temporary layoffs. As regards to the Labour Inspectorate, deadlines governing the operation and performance of the Labour Inspectorate are suspended, except in cases where its intervention is required to safeguard the protection of general interest or because these cases are related to COVID-19. Thus, for example, this suspension applies to terms for the Labour Inspectorate to conduct inspections, statute of limitation periods for actions to demand accountability for the breach of social order and social security regulations, and for liquidation cases involving social security payments. Finally, and as you may recall from our previous webinar, Royal Decree Law 11/2020 approved some measures regarding the moratorium on contribution payments and deferral of social security debts for business and self-employed workers. And now, the Royal Decree Law 15/2020 has included several amendments to those measures for the following purposes. First, to simplify the deferral resolution procedures, regardless of the number of monthly payments involved, to lay down an homogeneous criterion for determining repayment terms. Third, to establish the legal effect of the request until the procedure has been resolved as regards the suspension of administrative deadlines provided under Royal Decree declaring the state of emergency. And finally, to declare this referral incompatible with the moratorium regulated under Section 34 of the aforesaid Royal Decree Law 11/2020. So these measures that I have explained are pretty much all the labor and employment measures adopted by the last Royal Decree Law 15/2020 that we wanted to review with you, and that will not be probably the last ones. Now, we will move to a very hot topic, which is the company's, well, the safeguard of job, or the company's commitment to maintain employment for 6 months from the date the activity is resumed, included in the additional provision 6 of Royal Decree Law 8/2020. As you may know, this additional provision of Royal Decree Law 8/2020 establishes that the extraordinary measures in the field of employment included therein shall be subject to the company's commitment to maintaining employment for a period of 6 months from the date they resume business. During past weeks, we have had several discussions as regards to whether this commitment to maintaining employment applied to all temporary layoffs carried out during the state of emergency, or just to temporary layoffs based on force majeure. And this kind of temporary layoffs allow employers to benefit from an exemption on contribution to Social Security. In this regard, you are probably aware that companies with less than 50 employees registered as of February 29th could apply for a full exemption from payment of the employer's Social Security contribution, whilst companies with 50 or more employees could apply for an exemption of 75% of the employer's Social Security contribution. However, all employees affected by temporary layoffs based on the extraordinary circumstances defined in Royal Decree Law 8/2020 had the right to an employment benefit even if they not met the minimum contribution period required for such purpose, and the time during which the unemployment benefit is received for these reasons will not be included for the purpose of determining completion of the established maximum periods for receiving benefits. So therefore, it was not 100% clear whether this commitment applied to both kinds of temporary layoffs or just to the force majeure layoffs. Our criterion as a law firm was that this commitment should only applied to companies that benefited from the aforesaid exemption in Social Security contributions, since the rest of the extraordinary measures of Royal Decree Law were in favor of Royal Decree Law 8 2020, were in favor of the employees and not in favor of the company, because they were mostly related to the unemployment benefit. So the actual benefit for the companies was the exemption of Social Security contributions. This discussion and our position have been finally ratified by a ministerial order dated April 7th, which affirms that this commitment to maintaining employment only applies to companies that carried out a temporary layoff based on force majeure. Another relevant issue that came up in connection with this commitment to maintaining employment during the 6 months after companies resumed their activity was whether the obligation to maintain employment refers only to those employees affected by temporary layoff or to the whole staff of the company. Well, again, the ministerial order of April 7th clarified that the obligation to maintain employment refers to those employees affected by the temporary layoff and not to the whole staff of the company. So that's well, a good relief for most companies. But there was also a last major question in connection with this commitment. And this question was to determine what terminations could imply a breach of the company's commitment to maintain employment. The ministerial order again states that the only terminations that will not be considered as a breach of this commitment are disciplinary dismissal not acknowledged or declared as unfair, terminations of employment due to employees' decision, such as a voluntary resignation, or due to employees-related issues, let's say death or total disability of the employee, retirement of the employee, and so on and so forth. And finally, the expiration of the term of a valid fixed-term contract. So, any termination based on business-related reasons of an employee affected by a temporary layoff based on force majeure during the 6 months after the company resumes its activity could be considered as a breach of the commitment to maintain employment. In addition, as regards to fixed-term contracts affected by a temporary layoff, it's very important that these contracts have a valid cause, and as otherwise they could be considered as fraudulent and therefore as an unfair dismissal. That may imply a breach of the company's commitment to maintain employment. Finally, well, and can the company choose not to benefit from the exemption? This is, well, a question that we have received from our clients during past weeks. And many clients have been asking us whether they could choose not to benefit from the exemption in order not to be bound by this commitment to maintaining employment. Our answer in most cases, according to Section 24 of Royal Decree Law 8 2020, was that yes, since the exemption of the company's Social Security contributions was applicable upon request of the employer. However, during the state of emergency, the General Treasury issued several bulletins confirming the automatic application of the exemption in the Social Security contributions when registering affected employees by a temporary layoff based on force majeure before the Social Security Administration. So, although Section 24 of Royal Decree Law 8 2020 was clear on the fact that the exemption of the Social Security contribution was upon request of the employer, in practice, the General Treasury of Social Security automatically applied this exemption when companies registered affected employees for a temporary layoff. But finally, the General Treasury clarified this situation, issuing an answer to a question raised by the Social Graduates Bar, stating that it was possible for companies to opt out for the exemption to the Social Security contributions when filing a temporary layoff based on force majeure if the employers registered the temporary layoff as a regular temporary layoff based on business-related reasons. As a final note, the deadline to opt out for the application of the exemption of Social Security contribution is April 29th. So if your companies have carried out a temporary layoff based on force majeure reasons and do not want to be bound by the maintenance of employment commitment, they should inform the General Treasury of Social Security on or before April 29th. To this end, companies should file a recent submission opting out for the exemption of companies' Social Security contributions. And now I will give the floor to Lara, who will explain you the upcoming situation that most companies will face after the application of temporary layoffs in order to adapt its organization and workforce to the new reality that we will live during the next few months. So Lara, whenever you want.
Thanks so much, Alvaro. Let me just say that also on practical terms, if you have still not done the communications to the Social Security in terms of exoneration, I have to say that I have had a few clients for whom the Treasury did not automatically choose the exemption for the Social Security. If you have not yet given all the communications, we really recommend you to do this urgently, because the system is also not working perfectly fine, and therefore it needs a little bit of time to get all the information. So a very practical advice there, but something that you probably want to be paying attention to in the coming couple of days. Let me just go through a few other points that have to do with what happens after our temporary layoffs. And it has to do with the restructurings, for which we are already receiving quite a lot of questions. What happens with the next day after our layoff, or what happens if we change our mind in the future of the companies? So first thing is, does the fact that we've had a temporary layoff influence future terminations? And well, as Alvaro just explained, definitely yes. If we had to commit to the safeguard of employment conditions or employment contracts for a period of 6 months, that is absolutely one of the things that will influence the future terminations. But let me also say that there's two more things that would greatly influence that circumstance. One is that during the application of a temporary layoff, we will hardly be in a position to apply a restructuring. And this is because the nature of the temporary layoff is, as it says, is temporary in the sense that it's circumstantial. We are saying that there's a circumstance at this time on time that is not permanent, and therefore that requires a temporary measure by the company, which is a temporary layoff. If we want to restructure because the company is definitely not doing well for the same reasons, we will find a hard time restructuring based on the same reasons for which we requested a temporary layoff. Let me be very clear here. I mean that it has to be the same reasons, and that's what's going to make our life hard. However, if we're able to, on a case-by-case basis, find different reasons to argue why we are now on a structural and permanent reason for restructuring, as opposed to the circumstantial reason that brought us to the temporary layoff, we'll then be able to go for a restructuring. At this point, however, let me also point out the second circumstance I was telling you about that will influence our future terminations. It has to do with the moratorium on terminations. Royal Decree Law 9/2020 foresaw that during the force majeure and economic and technical and production grounds of layoffs, and in fact during the full force majeure, terminations of the contracts would not be considered as reasonable. So the law foresees that during this period of state of alarm, we will be unable to dismiss people on the same COVID-19 grounds. This will be considered as not justified. This also means, and in terms of what would these terminations be considered if we, however, did it, Well, what would happen is that they would be considered as unfair. So the company would need to pay severance as if there were no grounds for those terminations. And that would lead to severance compensation, except for employees who have a special protection. This is employees on maternity, paternity, or long-term sick leave, and some other employees such as works representatives. For those employees, termination would be deemed as void. And we have a big question mark of what happens if we need to undertake a collective redundancy during this period of time protected by Royal Decree 9/2020. What we look at this point is that collective redundancies have to be required that we have a justification for those. It has to be economic, productive, organizational, or technical reasons. But since the law already told us that this will not be justified reason during the COVID-19 situation, then there would be an argument for those companies in case of collective redundancies during this particular period of time that could find that employees argued that the dismissals are void. So for how long do we need to, will we be restricted from doing these terminations? Well, it's clearly the case that it will be during the state of alarm. That's very clear. So for companies who are in layoffs and undertaking measures that have to do with the COVID-19, it's very clear that there will be restrictions. But the royal decree that provides for all the extraordinary measures during the state of alarm, it will last not only during the state of alarm, but also for an extraordinary 1-month period. So if the state of alarm ended on May 9th, as foreseen right now, it would last for 1 more month. There's also some people who consider that this could be extended throughout the temporary layoff, as long as we have requested those based on the reasons of the COVID-19 during the state of alarm. So for part of the interpretations of this moratorium, there's experts who believe that this will last throughout the temporary layoffs. In our view, the big problem, as we said, is that the reasons for the layoffs cannot be at the same time circumstantial and permanent. And that would be, to us, the greatest problem with the dismissals. But in our view, probably the moratorium would last until 1 month after the state of alarm termination. As I said, it's a case-by-case analysis in terms of can we or can we not undertake dismissals, but there is certainly a restriction that is currently enforced, as I said, by the government. Will we be able to argue during the state of alarm and during this period of restricted dismissal non-COVID-19 reasons? Well, we've had a couple of cases, but to be frank, and as you may imagine, everything is, or almost everything is these days connected to COVID-19. So it is not easy to find reasons that are completely disconnected from the COVID-19, but there might be. We have some cases of companies that were already in bankruptcy before the COVID-19, and therefore we are being able to argue that the reasons were there before the state of alarm and before the COVID-19. But as you see, not easy to argue reasons disconnected from the state of alarm these days. Let me then go to 2 more very quick questions. One is in the same line of, can we restructure after or during this period of time? And let me just say that there's a few other circumstances that we would need to take a look at before undertaking restructurings, even if the restrictions on current dismissals were lifted. And this is, some companies might have prior commitments of safeguard of jobs. This is not unusual if companies had prior restructurings, and if you have investments or if you have companies in your portfolios, for example, that may have had prior restructurings, this is something that could be there in their agreements or in their company-based agreements, and that's a relevant point. And then there's a second very relevant point that we're just going to announce today, which is the contribution to the public treasury for employees age 50 and over. This is a system that is in place in Spain, obviously before the COVID-19, whereby companies that would use restructuring to get rid of employees of a greater age in comparison to younger employees, they would be obliged by the government to pay the unemployment benefits of those more aged employees back to the Social Security. So in essence, what happens here is the government is giving an incentive to companies who are using public funds to rejuvenate their staff to stop doing that. And the way they do it is by requesting the payback of all these unemployment benefits who have been dismissed and that have been chosen because they are of a greater age than other employees. The mechanics of this is quite detailed and quite difficult to explain in the time that we have today, but please bear in mind and keep in mind this contribution to the public treasury when undertaking temporary layoffs, because the temporary layoff is one of the reasons why the government may request those unemployment benefits back from companies who have used temporary layoffs. And finally, just a clarification of something we've been hearing a lot these days between reduction and suspension layoffs. You may have heard that the same procedure applied to suspension and reduction of working time. It's not exactly the same. So if we have to put people on temporary layoffs and we will be using full days of suspension for our organization of work. So if we tell some people, you will just be coming 1 day per week, or you will be working 4 days per week, and then not working for 1 day a week, that's a suspension system. When we're telling people that their working day is going to be reduced, and it has a limit because it can only be reduced between 30 and 90%, in those cases, we will be on a reduction of working time. In other words, if we tell people to keep coming to work on a daily basis, but on a reduced daily working time, this is technically a reduction of working time. And if we tell people that they will come also a portion of their total time, but we organize those on full days, this will be a suspension of working time. With that said, we have covered what we had for today. Again, this is only intended to give you an overview of what has happened in the past week. I don't know if, Anna, we are already out of time, but if we have one question maybe that we can answer, if our attendees want to follow for a couple of minutes, then let's go on.
Okay, thank you very much, Lara and Alvaro. That was very, very interesting. We have one question, Lara, and I think this is addressed to you because of your introduction. You were saying at the beginning that we expect some news tomorrow from the Council of Ministers regarding the downscaling of the lockdown in reference to certain activities. Can you give us any more information on that? Because I do believe it interests a lot of our clients.
Yes, I was saying that it's foreseeable that we find very relevant news in this as soon as tomorrow. This is because at least in the tourism industry, there is a lot of pressure that is being put to the Spanish government. At least that's the news that we have. In terms of issuing specific industry regulation, and in particular in terms of the tourism industry and hotel industry, what we know is that there's very serious conversations going on the potential extension of the force majeure for that industry for quite a long period of time. So at least until the summer or later. So that would substantially change the strategy and the business strategy for layoffs or other measures, and even for the forecasts of certain industries. So at least that's one of the points that are really at stake, maybe for tomorrow. I don't know, Alvaro, if you know something else or you've heard something else.
Yeah, thank you, Lara. Yes, we have several information confirming that, well, the new regulation that will probably be approved tomorrow will include some measures regarding the resume of activity of most tribunals, including the employment tribunals, and the reactivation of some judicial proceedings. So we expect to receive some news in connection with all this activity that was currently paralyzed because of the COVID-19 crisis, but we will see what happens tomorrow as regards to all the situation of our tribunals.
So again, this week we go back to a lot of news, and we will keep you posted as you are probably very much aware. We in the Innovation and Knowledge Department, we follow very closely all this news, and you can find all this information on our webpage at cuatrecasas.com. There's an area called Publications in English, where we keep current events very updated and try to keep our clients informed. So please to address yourself to it. And also, if you have any questions, particular questions, you can address them to queries.covid19@cuatrecasas.com. And please keep in touch and keep safe, because this is not over, and we have still a lot of things to do. And I don't know if Lara and Alvaro, do you want to add anything else to this webinar?
Well, just thanking everybody for staying with us this afternoon, and we hope to see you again in next webinars.
Thank you very much. Stay home and stay safe. See you soon.
See you soon. Bye-bye.